This module is about the impact that the House of Lords decision in Stack and Dowden had on the development of the law of the common intention constructive trust. The problem that faced the House of Lords in Pettit and Pettit was the need to decide on the ownership of the family home when a married couple divorce. The courts were later given the power to grant ancillary relief when a married couple divorce. By the time of the House of Lords decision in Stack, though, there had been a rise in the instance of unmarried cohabitation. The ancillary relief regime for couples does not apply to unmarried cohabitees. For these couples, property law in the shape of the common intention constructive trust plays a vital role. In a sense, the law of the common intention constructive trust is the unmarried couple's equivalent of ancillary relief. It must be sensitive to the family context without being too much of a departure from orthodox property law principles. The common intention constructive trust rests on a finding that the couple had a common intention concerning their respective ownership rights that's not recorded in the legal title. Where, as is commonly the case, there's no evidence of an express agreement, then the agreement must be inferred. In Lloyds Bank and Rossett, it was said that the intention could be inferred from direct contributions to the purchase price or from the payment of mortgage instalments, but from nothing else. In this respect, the common intention constructive trust could be said to be the same as the presumed resulting trust, but modified to take account of the fact that most people need to rely on mortgage finance to buy their homes. Stack and Dowden represents in some respects a departure from this Lloyds Bank and Rossett approach. In Stack and Dowden, an unmarried couple broke up. The couple were legal joint tenants of the family home. If they were also joint tenants in equity, then each would be entitled to one half of the proceeds of sale of the home. This was a case where the existence of the common intention constructive trust was not in doubt. The court was being asked to decide on the common intention as to the share that each of the parties was to have. Ms. Dowden claimed to be entitled to a larger share of the proceeds of sale to reflect her larger contribution to the purchase price of the family home. She succeeded and was awarded a 65% share in the family home to reflect her financial contributions to its purchase. The judgment is significant, however, not so much because of the outcome as the reasoning on which it's based. I refer to the judgment given by Lady Hale, since most of the other members of the House of Lords agreed with her. Her judgment has often been referred to in later cases. One of the significant ideas to emerge from the Stack is the presumption of a beneficial joint tenancy where a couple are legal joint tenants of the family home. In paragraph 68 of her judgment, Lady Hale says that it would be very unusual if there were not a beneficial joint tenancy in these circumstances. The House of Lords is keen to help couples avoid lengthy and expensive litigation. Their preferred solution is for the couple to record their ownership intentions in the document transferring title to them. Where this is not done, the next best solution is clear guidelines as to the principles that the courts will follow, so that advisors can predict the likely outcome without having to trouble the court. The creation of a presumption of equality is intended to achieve this goal. Perhaps the most significant feature of Lady Hale's speech is her approval of the idea that if the parties have not expressed their common intention, then it can be inferred from the whole course of dealing. The court should carry out a survey of the whole course of dealing between the parties and taking account of all conduct which throws light on the question what shares were intended. This suggests that the emphasis is no longer exclusively on financial contributions as a guide to intention. This is borne out by paragraph 69 of Lady Hale's judgment, where she says that many more factors than financial contributions may be relevant to divining the parties' true intentions. She then goes on to give a long list of features of the whole course of dealing, which might be a guide to the couple's ownership intentions. In paragraph 70, Lady Hale goes on to say that even this long list is not exhaustive. A significant feature of the whole course of dealing in the family home context is often the nature of the emotional and financial relationship between the parties. It will often be the case that the relationship was one which Lady Hale describes in paragraph 87 as a real domestic partnership. The couple thought of their assets, including the family home, as being their joint property at the service of their mutual commitment. Once the existence of a common intention constructive trust has been established, a finding that the relationship was of this sort would lead to the conclusion that the couple were beneficial joint tenants of the family home. There is, we've already seen, a presumption of a beneficial joint tenancy when the family home is in joint names, but it's only a presumption. The presumption can be rebutted by relevant evidence, as happened in Stack itself. The couple were found to be beneficial tenants in common in unequal shares. The relevant evidence in Stack was that the couple kept their finances rigidly separate. This suggested to the House of Lords that they were not a domestic partnership and that they intended to have separate ownership rights in the family home. Where there's no domestic joint venture, the whole course of dealing allows a wide range of factors to be considered. In practice, the focus is often on the financial contributions of the parties to the purchase of the home, including mortgage instalments. In this sense, the whole course of dealing often closely resembles the presumed resulting trust. All of the members of the House of Lords agreed on the outcome, but Lord Newburgh expressed his concern about the whole course of dealing approach. He thought that it allowed the court to have regard to too many factors. He thought that this could lead to a lack of certainty. Lord Newburgh argued that the presumed resulting trust should be used. He suggested ways in which the presumed resulting trust could be improved, allowing mortgage payments to be taken into account, for example. He pointed out that in Stack, the House of Lords had effectively applied the presumed resulting trust, while purporting to have regard to the whole course of dealing. In Pettit and Pettit, the House of Lords had rejected the idea that the courts could impute an intention to the parties that they did not actually have. This approach, if accepted, would allow the courts to use fairness as the criterion to decide on what shares the parties should have. Lady Hale confirmed that the court's search was for an actual intention, but not before a passage in which she seemed to suggest that imputation and the use of fairness might be permissible. In paragraph 60, she says that the search is to ascertain the parties' shared intentions, actual, inferred, or imputed, with respect to the property in the light of their whole course of conduct in relation to it. In the next paragraph, however, she confirms that the court is giving effect to the parties' actual intentions, and it's not imposing its view as to what would be fair. In the later case of Jones and Kernet, the UK Supreme Court, with Lady Hale giving a joint judgment with Lord Walker, went further and accepted that the courts could impute an intention to the parties. The intention to create the common intention constructive trust cannot be imputed, but imputation can be used as a last resort to decide on what share it would be fair for each party to have. Paragraph 60 in Stack might be seen as an early warning of this eventual acceptance of imputation. Lady Hale refers to the difficulty in legislating for an ancillary relief regime for unmarried couples. She refers to the work that the English Law Commission was doing in this area. This legislative void creates a problem for the courts. The result is that the evolution of the law of property to take account of changing social and economic circumstances will have to come from the courts rather than Parliament. There's a clear sense that the courts are doing their best to fill a gap that will be better filled by legislation. Stack and Dowden was solely concerned with the quantification of each party's beneficial interests. In later cases, such as Abbott and Abbott, it was accepted that the court could also infer the existence of the common intention constructive trust from the whole course of dealing. Despite this, it's clear that only direct or indirect contributions to the purchase price or mortgage payments are used to infer the existence of the trust.